So just some considerations there from a chain of custody perspective. Um, so confidential and legally privileged. So that statement, when you're managing incident response engagements with alongside lawyers, you'll see that statement. You'll say it again and again and again and again in every single email that you send and on every single document that you send, right, or that you create. So ultimately, legal privilege is to protect the communications between the lawyer and the client, so that those communications don't have to be exposed in court, or if the government issues a notice, for example, to be able to request all of the information about the security breach. You don't have to disclose the communications with your lawyer. So one of the landmines that we come up against with incident response, and this is the most common and across nearly every incident response, is that, as I mentioned, there's lots and lots of unknown questions at the start. To answer some of those questions, we get engaged by, say, our client directly to do the incident investigation to get some quick answers. And then they realize that, oh, actually, this looks quite serious. We better bring in the lawyers. And then the lawyers, the communications between the lawyers and the client at that point in time are now privileged. However, at that point, we're still not privileged, right? Because we're being engaged directly by the client. We're not being engaged by the lawyers. So what has to happen is that the lawyers actually send a formal engagement letter to us as the IR provider, and they say, we're formally engaging you in order to provide legal advice to our client around the security breach. And so we cease to have you as the client for the security breach at that point in time, and the lawyers are now technically our client, right? And that means that the communications that we have between yourselves and your lawyers is all considered privileged, right? And that doesn't have to be disclosed. So one of the problems with that is that prior to being engaged formally by the lawyers, all of the communications that we've had prior to that are not privileged. And that means that if the OAIC issues a notice to say you have to give us all of the information that you've got about the breach, you have to hand over all of the emails and documents prior to that point. Another one is that a lot of people think that legal privilege, if a lawyer's brought in straight away, then all of the security breach is privileged, right? Whereas what actually happens is that only the communications with your lawyers is privileged, but all of the data relating to the security breach is not privileged. And for the reason for that is because the security breach happened irrelevant to whether the lawyers were involved or not, right? So all of the data, backdoors, and the timeline of the events and things like that all happened, irrespective of the lawyers, and therefore none of the data, relating to the breach is privileged, but the communications and the analysis of that security breach is privileged, right? As long as that's covered by the agreement with the lawyers. So, as I mentioned, nearly every incident starts off that way, where it's not privileged. You need to get some initial answers and get a quick response, and then they start engaging, the lawyers, and then from that point on, it's all privileged and protected. So there was a incident that we were involved in where exactly that happened. It was quite a way. We had an existing incident response retainer with this client, and it was quite a way into the security breach investigation when they brought the lawyers in to actually get us brought into being engaged by the lawyers, and therefore our communications were privileged. However, that left a good few weeks of communications and discussions and documents and even the reporting that was not considered privileged. And so we actually were issued a notice by the OAIC, and we had to give over all of that information to the OAIC. So what happens when you receive a notice? You have to do what's called e-discovery to identify every single email across all of the team members who are involved, every single file and document related to the security breach. And you actually have to then format those into a specific, quite detailed format, into a spreadsheet that thereafter you have to go through every single email or chat message or report or data item, determine if there's any personally identifiable information in the document. You have to classify whether it's privileged or not, or partially privileged, and we'll touch on that in a second. As well as potentially even marking, censoring some of them because of conflicts with privilege, which again we'll touch on in a second. So as the security breaches get bigger, that e-discovery cost can spiral a bit out of control. If even when we were dealing with tens or hundreds of thousands of documents, when it gets to millions of documents, that e-discovery process can become quite expensive. Okay. Actually, before we move on from that, so one other thing just to keep in mind, which is another landmine, is that even though you can mark the documents as, say, the emails as confidential or as privileged, the actual OAIC can request that you must include the email subject in the spreadsheet of all of the documents that you've got relating to the breach. If your email subjects are quite detailed, they can actually start leaking information that is considered privileged. So it is, you can refuse to provide the email subjects to, say, the OAIC, but it's just a judgment call to be able to, as to whether you want to annoy them and play hardball, or if you want to say, right, we'll allow that piece of information to leak out because it's not going to be critical to our investigation, for example. Okay, so legal privilege can end up in a bit of spaghetti when you start involving multiple parties. So when you start getting multiple vendors involved in major security breaches who are getting engaged at different points throughout the investigation, you start to get this privilege spaghetti where, if there was a point in time, like I said before, we were engaged a few weeks into the investigation by the lawyers, which meant that, part of our investigation was not privileged and part of our investigation was privileged. Other parties were brought in and they were privileged from the start. And so when you get emails, for example, or documents that are being added to by multiple parties, it starts to get complicated as to whether that email is privileged or not, for example. So, if you've got our team on it who, let's say we were not privileged at the time, but then you've got, two other parties on an email thread who are under privilege, is that email covered by privilege or not? And so it does get complicated to determine whether a document or an email is privileged or not, because you then have to understand everyone who's involved, when they were brought on, when their privilege was enacted, and then determine whether every single document that you've got related to the breach is actually privileged or not. And so that's a bit of a minefield, because you don't want to unintentionally, as a vendor, be handing over privileged data to, say the OAIC, for example, which then breaches, the legal privilege of the client unintentionally. We actually, whenever we provide documents to the OAIC, we always include a letter stating that if there is any privileged information or privileged documents provided unintentionally, then they must be redacted, and removed from their systems. So one of the loopholes that you get with security breach investigations around privilege is phone calls. So typically you get asked for documents and emails and chat messages and things, but you're not getting asked to provide transcripts of your phone calls or anything like that. So you tend to need to be in emails with the lawyers involved, with the client, so that, it's because technically when you're engaged by the lawyer, they're our client, remember, and therefore they need to be on the email threads whilst we're talking with you as the end client. However, phone calls, the lawyers seem to say, no, go for it. You can just go and give them a call and, go and sort out getting access to something, or, ask some questions about, information about their environment and those sort of things. We don't have to be on those phone calls. And ultimately that's because, that relies on the memory of the conversation. If you think about some of these court cases, might be a year, 2 years, 3 years down the track. It's not trustworthy to be able to rely on some of that evidence based on a phone conversation. Okay, so the other part that comes into legal privilege is what's called the dominant purpose. And ultimately, when we're looking at that privilege spaghetti as to determine what's privileged and what's not privileged based on multiple parties being involved with different privilege at different times, ultimately there's a general rule, which is the dominant purpose, it needs to be for the dominant purpose of providing legal advice to the client. Right? So what that means is when you're doing your discovery and you're analysing some of the documents or the emails to be able to determine, is this privileged, and therefore I don't need to hand it over to the OAIC, you have to look at, all right, well, this email is not privileged for us. However, it may be privileged for this other third party. So we've done plenty of incident investigations with CrowdStrike. We've had a look at it and gone, all right, well, CrowdStrike have been engaged with privilege because they were brought in later on. For this email, is this for the dominant purpose of CrowdStrike, or is it the dominant purpose for us? And if the dominant purpose is for us, then the email is not privileged. If the dominant purpose is for CrowdStrike, so for example, CrowdStrike have, said, we need to gather information about X, Y, and Z, and we've then chimed in and provided some information, then that email conversation is privileged because it was for the dominant purpose of providing that information to CrowdStrike in this case. All right, so that dominant purpose helps to give a guide as to what's privileged and what's not privileged, but it is can be subjective. and the OAIC can get a little bit on edge, or their lawyers anyway, can get a little bit on edge around it if you take the liberties a bit too far with that subjectivity. Okay, so another sensitive issue is actually the security recommendations. So you've gone through and we've done the incident response engagement. We've identified a whole bunch of issues within your security architecture or your security posture, and we've written up the incident response report. We've included a whole bunch of recommendations on to how to improve your security to prevent the breach from happening again. Those recommendations can actually be seen or constructed in court to be admissions of fault, right? And so we obviously don't want to have admissions of fault when you're in court, because that's not going to help your case. So that's a bit of a landmine that a lot of incident response teams will actually include those recommendations in the investigation report instead of splitting those out into a separate report. So we actually had one legal team, so third-party lawyers for a client, who actually told us not to provide any recommendations, and they made us take our recommendations, leave our recommendations out. And so we provided the incident response report. That ended up, we were presenting to the OAIC, and during those preparations for us presenting to the OAIC, we were consulting with our own legal team, and they were saying that actually that exposes us as the vendor. By not providing recommendations, we can be, claims could be made that we haven't provided sufficient advice to be able to actually protect the client from suffering another breach. So there's a few recommendations around that, and a bit of a middle ground, which is that the factual investigation report be kept in one report, and that way that report can be sent to authorities quite safely without necessarily admissions of fault. A separate recommendations report is provided that goes to the client, and obviously they can use that to enhance their security. That also protects the vendor from not providing sufficient advice to be able to secure themselves. And then by doing that as well, it also provides the lawyers with the flexibility to be able to restrict access to the recommendations, but still allow their client to be able to protect themselves. And a lot of IR companies don't tend to take that into account.